In addition to the 8 categories of copyrightable subject matter under Section 102A, it's important to note 2 other types of copyrights that you can obtain. Importantly, these are not 2 new categories of copyrightable subject matter. Rather, these are 2 types of copyrights that an author can obtain in any category of copyrightable subject matter. The first of these types of copyrights is a derivative work copyright. Derivative work copyrights are copyrights where the work created by an author builds on or derives from an earlier work. So example is a sequel to an earlier film. This sequel may well take many of the protected characters and some of the protected copyrighted expression from an earlier book or movie and use it in a second book or movie. However, there's also a lot of original authorial expression that goes into a sequel. Therefore, this is a derivative work. It is a work that builds on a previous work but is itself copyrightable. Another example of a derivative work is a work in which you change the medium. So someone who has written a novel may have that novel turned into a movie. The movie is a derivative work. It builds on a pre-existing work but adds something new as well. Importantly, the derivative work right a derivative copyright is limited in its scope because the protection given by copyright only extends to the original contribution of the derivative work author. So as we've noted earlier, if in fact someone copies from a derivative work material that was copied from an underlying work, there may be a cause of action by the author of the underlying work, but not a cause of action by the author of the derivative work. Furthermore, if someone copies from the derivative work some expression where the derivative work author has added original expressive content, and furthermore, it also incorporates original expressive content by the underlying author, then the copyist, the third copyist, the person who is copying the derivative work, may violate the copyrights of both the derivative work author and the author of the underlying work that was the basis of the derivative work. So that's derivative work copyright. The other type of copyright is a copyright that's called a compilation copyright. Compilation copyrights occur when people assemble together, collect a number of distinct pre-existing works. So you can think about it as a periodical issue or an anthology or an encyclopedia in which a number of distinct authors' works are simply combined and presented together without modification within any of those individual works. Here there is a copyright in the compilation because there can be originality in the selection, coordination, and arrangement of the pre-authored works. In much the same way, we asked whether it was possible to have a copyright in a phone book because there was an original selection, coordination, and arrangement of the facts therein. You can have a copyright in a compilation because there is original expression involved in choosing which works get put together and exactly the way in which those works are put together. But as with the derivative work, it's important to understand that the copyright in the compilation is rather thin. If someone copies from a compilation one of the pre-existing works, the author of the compilation has no cause of action for copyright infringement. There, the cause of action for copyright infringement is the original author has that cause of action because it's their expression that has been copied. The compilation author only has a cause of action. Their rights only extend to the situation where the entire compilation is copied or something very close to the entire compilation is copied because the author of the compilation only has a copyright insofar as the original selection, coordination, and arrangement of the pre-existing articles is copied. Thank you.